I'm grateful to the Right Honourable Member for Kenilworth and Southern for securing this debate. It is right that this House examines Sir Brian Levison's review with care before any legislation is brought forward. As someone who spent many years at the bar, as a prosecutor as well as a criminal defence lawyer before becoming an MP, whilst as a Member of Parliament, I challenged at the dispatch box many a time the ministers about the fact that we had this record delay of cases in the Crown Court. Recently, when the public was asked by the Roundtree Foundation which rights should be protected in a Bill of Rights, only two things topped the list: the right to NHS care and the right to trial by jury. It is a constitutional safeguard rooted in public trust. Sir Brian's report exposes the scale of the crisis, the record delays, cases listed years into the future, and justice slipping beyond reach. Yet, in Bolton South and Walkden, as a result of the current government's expansion of court sitting days, we've been able to reduce some of the backlog. But capacity is not just about building, it's about people. Senior barristers, not only juniors, are leaving the criminal practice because the fee structure cannot sustain a career. Judicial shortages mean we lack the judges, recorders and district judges needed to run the additional courts. This hasn't happened by accident. It was as a result of 14 years of Conservative governments, court closures, sitting days cut and legal aid eroded. These were political decisions. But before contemplating such constitutional changes, such as limiting jury trials, we should act on the most basic recommendation in this review, such as increase sitting days now, use the court to their full capacity, and if you want earlier guilty pleas, defendants must have access to timely legal advice, and that also means that the fee structure for payment of this has to be re-examined as well. There are proposals, many sensible proposals in the review, such as support for criminal pupillage and improved case preparation. But honestly, they cannot justify removing the right to jury trial or curtailing the right to appeals, particularly as when we know that over 40% of appeals from the Magistrates' Court to the Crown Court currently succeed. We cannot allow a result of delay by reducing scrutiny. We cannot deal with the issue of delay by getting rid of jury trials, which is one of the foundations of our civilised society. I know there have been some changes already made, but I think it's so fundamental to our system. We need reform, but it must be strengthened trust, not to weaken it. Because when justice fails, it's only individuals who suffer. It's the confidence in our entire system that is lost.